Ladies and gentlemen, distinguished guests, thank you for coming today to the 4th Cyprus Forum. We're going to start now the panel discussion on transparency and rule of law. I would like to give the floor to Mr. Christos Clerides, the President of the Cyprus Bar Association. Mr. Clerides, the floor is yours. Thank you very much.
Thank you very much. My congratulations to the organizers of this invitation. My topic is how much transparency do we need? On the one hand, the public tries for more and more transparency. But on the other, yes, I hope I will be able to enlighten you today, the courts trying to curb this insatiable desire for complete transparency. Yes, such a state of affairs may prove harmful to the individual human rights. I will refer to examples from Keynote of the European Court of Human Rights and the European Court in Luxembourg to illustrate my point. So my main point is that there has to be a balance between the need for transparency and, on the other hand, the need to protect individual rights. And this, of course, emerges from the jurisprudence of the Strasbourg and the Luxembourg Court. This matter is of great importance for us lawyers, of course, because on the one hand we have a duty to keep confidential information and documents of our clients in secrecy. This is part of the tradition. But on the other, as officers of justice and gatekeepers, which is the latest catchphrase, imposing duties upon lawyers to fight against corruption and money laundering, we are considered to be the gatekeepers. We have to supply and give some information to the authorities, and that is by virtue of statutory provisions. The matter came up as to this balance that has to be struck recently before the Luxembourg Court in a very important case, 8th of December 2022, concerning the directive relating to the field of taxation, known as taxes. This directive of the European Union imposes reporting obligations on lawyers. Member states may take measures to waive the reporting requirement relating to tax matters or cross-border arrangements where this would breach legal professional privilege. In a case referred to by the Belgian court, it had to be decided whether lawyers who are protected by this legal privilege and have no obligation as to reporting would nevertheless be forced to notify to other parties involved in the transactions that they have been consulted in connection with a case involving cross-border arrangements and hence tax implications. This directive was intended to combat tax evasion, not only tax evasion. Under the directive, there was this So the court had to decide whether this obligation to report to other parties involved by the lawyers of one party that they were involved in the process, which is mandatory under the director, infringe this legal privilege of the lawyer. So the court ruled that Article 7 of the Charter on Fundamental Rights, and the Charter of the European Union, not the European Convention, guaranteed the secrecy of the legal consultation, both as far as the content, but also its very existence. So to reveal that you have been consulted as a lawyer would infringe this privilege. Not only you are protected not to reveal the contents of the consultation, but also the very consultation is protected by Article 7 of the Charter on Fundamental Rights. So the court upheld the objection and struck down the directive as violating the doctrine of legal privilege. The court, in reaching this decision, made this balancing exercise to which I referred. On the one hand, the public interest and the need to avoid tax evasion, but on the other, put in the balance the necessity to protect individual rights of clients consulting lawyers and the duty of lawyer to keep the consultation in confidence and not to reveal it to anyone. The court came down in favor of legal privilege and the protection of the right of secrecy, including the right not to disclose that a client has consulted the lawyer on any particular matter. The European Court of Human Rights has a very rich jurisprudence on the protection of legal privilege, but as I shall explain, the Human Rights Court does this balancing exercise again between the public interest and the individual interest, which necessitates the protection of legal privilege. And as we will see, in most of the cases, the legal privilege prevailed as opposed to the public interest. But always the balance has to be carried out. In the leading case of Michaud versus France, it was decided by the court that the confidentiality is of crucial importance in a democratic society as far as the relationship between the lawyer and the client is concerned. In some cases, bank statements of a lawyer would not be released to the police, as this violated an applicant's right, lawyer right, to respect for professional confidentiality. Interception of notes exchanged between the lawyer and the client was held impermissible by the Human Rights Court. Monitoring of an applicant's law firm's telephone lines in the context of criminal proceedings to which he was not a party, but only a third party, was found again to constitute a violation of Article 8 of the Convention, which guarantees the right to privacy and to family life. Interception of a suspect's telephone communication with counsel is not permitted. In other words, the police cannot intercept the communication between the lawyer and his client, which is deemed to be a violation of Article 8 of the Convention. The intersection of telephone conversations of a lawyer and his inability to challenge the lawfulness of the measure and to request that the recording be destroyed, again was found to be a violation of Article 8. In the very well-known case, which is also applied by our courts, Niemiec versus Germany, 1992, a warrant of search in a lawyer's premises and the collection of files from a lawyer's premises violates Article 8 of the Convention, especially when the warrant is drafted in very broad terms. In that case, the police had a warrant of search and took a considerable number of files from the lawyer's office, related or unrelated to the case. This was found to be a violation. There are many cases, I'm not going to go through them. I just gave you some illustrations. I will now go to the exceptions to this basic rule, where it was held that despite the protection of this right, there are certain cases where lawyers may not be protected by legal privilege. And the most important case is the one I have referred to, Michaud versus France, 2012, where the case concerned, and this is very important, the obligation of lawyers to report their suspicions regarding possible money laundering of their clients. The court held, that is the Strasbourg court, that this reporting obligation does not violate Article 8 of the Convention, because the obligation of a lawyer to report money laundering pursues a legitimate aim of prevention of disorder or crime, since it was intended to combat money laundering and related criminal activities. The interference was not disproportionate with the legal privilege, since lawyers were not subject to the above requirement when defending litigants. So, this is a classic case of money laundering. We have to report it as lawyers, even if this would violate, strictly speaking, our confidential privilege towards the client. It's one of the exceptions. Money laundering. So the court again puts into the balance the public interest as opposed to the individual rights. And in the field of money laundering, it has considered that the public interest is of paramount importance. Also, in cases of tax fraud, investigation of clients, this is also deemed to be permissible, where tax fraud matters arise. Generally, tax investigations are an exception to the rule. The court again puts into the balance the conflicting interest and leans in favor of the economics of the country concerned. So, money laundering, tax are two very important exceptions. So, what is important to bear in mind is that the courts are the ultimate judges of how much transparency we can have. It is not what the parliament will say, it is not what the government will say, ultimately is what the judges will say after doing this balancing exercise. So, the answer to the question, how much transparency, is so much that the court will allow. And in deciding this, the court will put into the balance the public as opposed to the private interest. Thank you very much.